Okay, I think we're going to go ahead. Can you hear me? Yes? Hello, hello? I think we're going to go ahead and get started with our last panel of the morning. This panel takes the conference theme, I think, at face value. I know we've spent the morning talking about the other declarations, the state declarations of rights drafted alongside 1776. The next two papers show that these documents weren't aspirational window dressing. They did real legal work that the federal Constitution couldn't or wouldn't do. And in both cases, the distance between what the states said and what the federal text omitted tells us something important and something I think that's worth discussing. I'd like to introduce our panelists today, starting with Robinson Woodward-Burns. He's an associate professor of political science and the director of graduate studies at Howard University. He's also the author of Hidden Laws: How State Constitutions Stabilize American Politics. His paper examines Jefferson's deleted anti-slavery clause alongside 42 state-level non-importation resolutions and argues that the real story is considerably messier than either side of our modern debate wants to admit. Next to him, we have Josh Windham. He's a senior attorney at the Institute for Justice. He litigates economic liberty and property rights cases with a focus on state constitutions. His paper defends Pennsylvania's heightened rational basis test, a test he has personally litigated as an attorney at IJ, and a test that he traces directly to Pennsylvania's 1776 Declaration of Rights. Next to me, we have Professor Robert Cottrol. He is the Harold Paul Green Research Professor of Law at GW. He is a leading scholar on race, arms, and constitutional history, and his most recent book, To Trust the People with Arms, won the 2025 Cooley Book Prize. He will be providing commentary on both papers. Last but not least, my name is Keith Neely. I'm an attorney at IJ, and my principal qualification for moderating today's panel is an affinity for structure and an appreciation and ability to tell time. So here's how today's panel will proceed. Robinson is going to start first, and he'll have about 10 minutes to present his paper. Josh will follow and have about 10 minutes to present his own, and then Professor Cottrol will provide about 10 minutes of his own commentary. That should leave us an additional 15 minutes of back and forth and an opportunity for both Robinson and Josh to respond before we open it up to all of you for questions. So without further ado, Robinson.
Thank you very much for the kind introduction, Keith, and thank you, Robert, for being here. Thank you also to the Institute for Justice and to George Mason University. I'm here to talk a little bit about a clause that did not appear in the Declaration of Independence. It's a clause of which y'all may have heard in the original draft of the Declaration of Independence, or what's sometimes called the original rough draft. Jefferson included at the end of his list of grievances against George III a complaint, namely that George III, that the British, the Crown, had maintained the slave trade, the transatlantic slave trade. It's a long clause. Jefferson wrote it as the culmination of that list of grievances and sort of the rhetorical crescendo of the Declaration. And so I won't read the whole clause, but I'll read three parts of it, or I think three clauses of it. Jefferson faulted George III, saying, quote, "He has waged cruel war against human nature itself, violating its most sacred rights of life and liberty in the persons of a distant people who never offended him, captivating and carrying them into slavery in another hemisphere, or to incur miserable death in their transportation thither." Ellipsis. And quote, "He has prostituted his negative for supporting every legislative attempt to prohibit or restrain this execrable commerce, and that this assemblage of horrors might want no fact of distinguished dye, he is now exciting those very people to rise in arms among us." Jefferson here is saying a few things. One is that the international slave trade is inhumane. Two is that the Crown has vetoed attempts among colonists to abolish or to regulate or tax the international slave trade. And three is that the Crown, or agents of the Crown, and here implicitly is referring to the royal governors, incited revolt by enslaved people. Immediately after the clause, after the original declaration was pushed or was offered to Congress, members of Congress, they're named, but unnamed delegates from South Carolina and Georgia, two primary slave importing colonies, and also unnamed delegates from northern colonies responsible for importing or trading slaves, forced the deletion of this clause. Famously, Adams, who was responsible for editing the Declaration and who largely favored Jefferson's clause, thought that the language, the anti-slavery language, was too strong. He called it a vehement Philippic. His wife, Abigail, then wished that, quote, the most manly, she regretted rather, that the most manly sentiments in the Declaration are expunged from the printed copy. Jefferson later, through a printer in Richmond, in 1806, circulates the clause, and for much of his last 20 years, he sort of pushes this reading that his intention behind the Declaration was to write an anti-slavery document. Later abolitionists will promulgate this clause, especially in the era just before the Civil War, after the Compromise of 1850, in which the federal Constitution, later under Dred Scott, is used to push slavery in the territories, to capture fugitives from enslavement in the North. Abolitionists like Frederick Douglass, Garrisonians, Wendell Phillips, and even Abraham Lincoln point to the redaction of this clause to suggest that the Declaration had underlying and neglected anti-slavery sentiments. And even now, we still sort of push that story. Nicole Hannah-Jones, in her 1619 project, says that the deletion of this anti-slavery language suggests the Declaration actually was a pro-slavery document, that the framers of the Declaration wouldn't tolerate anti-slavery language. Now, in a sort of slapdash response to that, at the end of the first Trump administration, the 1776 report says, no, this is an anti-slavery declaration. We ought to take the original copy of the Declaration to establish its true meaning. Uniting all of these responses and some scholarly interpretations of this is the idea that, in fact, this declaration, that this redacted clause is an earnest anti-slavery clause. And I don't think that's right. I actually came here to talk about state constitutions, and so where they come in. And then, you know, it's nice, I should add as an aside, to be in a room where people want to hear about state constitutions. Only 52% of Americans think state constitutions exist, and I assure you they do. So how might we actually understand what this clause really means, the deleted clause? There's not much besides the clause. Jefferson rephrased it twice in his second and then in his third draft of the Declaration. If you look at state declarations and similar state resolutions framed immediately before the U.S. Declaration and those framed immediately afterwards, we get a new interpretation of the clause which suggests it's not so earnestly anti-slavery, but rather one that puts emphasis on the latter part of the redacted clause that suggests that the real complaint here was one over taxation and veto power, that George had regularly, that the Crown had regularly vetoed colonial legislative attempts to either wholly ban or to tax importation of enslaved people, and also that the Crown, through its agents and royal governors, had attempted to incite slave revolt. So what I'll do is I'll sort of, in the remaining 5 minutes or so, do this in 3 parts, and I'll just highlight a few of these. There were 42 non-importation resolutions that I look at, but W.E.B. Du Bois, in a really sort of capacious work on the Atlantic slave trade, one that's now 130 years old, looks at all of the non-importation resolutions from the very sort of founding of the British American colonies up to the 1787 non-importation clause of the U.S. Constitution. So I'll first talk about the ones that come immediately before the Declaration, then I'll talk about a few non-importation resolutions and state declarations that come alongside the Declaration, and then I'll talk about ones that come afterwards. And I think when you put these state-level resolutions in context with the Declaration, you get sort of a fuller sense of the Declaration's actual meaning. So, original bans and non-importation resolutions at the colonial level were often wholesale bans framed in the language of man stealing. So Connecticut, for example, 1672 says, if any man stealeth another man or mankind and selleth himself, he, or if he be found in his hand, he shall be put to death. This is put in the language, and they cite Exodus 21:16 in the language of sort of Old Testament punishment for capturing another person unjustly, language that Locke himself later uses in the fourth chapter of the Second Treatise. It's only when we start to get slave revolts, New York has a slave revolt in 1712, really famous one, that southern states particularly start pushing really hard to tax the number of enslaved people being imported into the borders of their colony, often with the express sort of worry that overpopulation, South Carolina is one of these colonies, will yield slave revolt. Virginia actually, in the 1760s, later starts to note that reliance on the tobacco crop and on slave labor is also impoverishing the colony as cycles of boom and bust in tobacco and to some degree in cotton, also in rice in the southeastern colonies, forces the colonies into this sort of mercantilist reliance on the British. So in Virginia, Albemarle and Nassau counties in 1762 push a non-importation resolution. Thomas Jefferson helps write one in 1772, 1772 and 1774. The legislature, the House of Burgesses, actually pushes non-importation laws in 1769 and 1772, and then it's actually the royal governor who forces Governor Spotswood, who forces the colonies or who vetoes the colonies' non-importation resolutions. So much of this sort of the clash between royal governors and the legislatures is in the background as the Continental Congress is meeting, and as it eventually deputizes Jefferson with and the Committee of Five, his four co-authors, with writing the Declaration. The Committee of Five, made up of Jefferson, Sherman, Livingston, and then Adams and Franklin, they picked Jefferson to write the Declaration. At the same time, this is in May of 1776 into June, he's writing a constitution for the state of Virginia. Virginia is the fourth of the original states prior to the Declaration to write its own constitution. And so in his early draft constitution, he basically writes language that he later imports directly into this clause. And he's writing it with an eye towards what's happening in Virginia. Several months prior to that, Lord Dunmore, John Murray, the royal governor, had seized gunpowder from the state magazine and encouraged on November 5th, 1775, the state's enslaved people to revolt in exchange for their liberty. So this is what Jefferson's referring to in his declaration. You would be hard-pressed then to say that in the context of what the state resolutions in Virginia and similar ones coming out of South Carolina, which had in that period also declared its independence, and New Hampshire, that there was an understanding that these were documents attempting to establish the colony's right to regulate the slave trade and prevent slave revolt as they wanted. And so it's likely the case that framers of the Declaration probably had some, and the Continental Congress who forced the deletion of this, those who forced the deletion probably had some issue with Jefferson's vehement philippic, as Adams put it, but they probably didn't have a problem with Jefferson's attempt to regulate the international slave trade. So finally, to conclude, the Declaration passes without this language. The state constitutions that succeeded in their declarations of right and declarations of separation afterwards make relatively few direct mentions of slavery. For the Vermont Constitution of 1777 is one of the exceptions. Rather, state constitutions like Massachusetts make an appeal to equality, or others make an appeal to liberty, like New York's, that are later used to pass non-importation resolutions or to pass gradual emancipation statutes. And it's through these, and ultimately through the 1787 non-importation clause in the federal constitution, that some of the commitments in the Declaration towards non-importation are finally realized. My goal here is simply to show that when you look at the Declaration of Independence in context or conversation with state non-importation resolutions, state declarations of rights and separation from Great Britain, that we get a slightly more nuanced picture of what the Declaration actually says. Thank you.
This thing on? Okay, you can hear me. Okay, so I think one thing that's fun about my paper and my presence here is that I'm I'm not a historian. I'm not a political scientist. I'm a lawyer. And so I come at things from a bit of a different angle. And it's fun to have, I think, that different perspective in ways I feel outside of my depth because, we have sort of intellectual and historical giants in the room. But I'm going to give it a crack. So my paper starts with a legal issue that I litigated and is really designed as a response to an argument I never got to respond to. And so in a way, I'm just this is a bone I had to pick for many, many years. And you're going to hear about the bone. So I litigated a case in Pennsylvania involving, I'll tell you a little bit about the legal dispute because it's important to know that before you know the history I'm going to dip into. So a woman named Sally Ladd, she was somebody who basically helped people use Airbnb. She had folks in her neighborhood who were doing short-term rentals of their cottages in the Poconos, and she was really good at renting her cottages out. And her neighbor said, hey, can you help us do that too? And so she kind of helped them use Airbnb, post the pictures online and respond to inquiries and that kind of thing. She would arrange for a cleaner to come between the rentals. And she was earning a living and having a really good time with this and sort of living out she's older, so she was in her retirement stage, and this was an important source of income for her. And then the state of Pennsylvania came to her and said, hey, you're an unlicensed real estate broker, so you have to shut down right now. Sally, of course, didn't buy or sell houses, wasn't managing apartment complexes, wasn't doing the sorts of things that traditional real estate brokers do. And so she was pretty shocked to get this call that she was under investigation. And she took a look at what would I have to do to get a real estate broker's license. And she learned that she would have to spend 3 years apprenticing for a licensed broker. She would have to open a brick and mortar office, which she didn't need because she just did all this from her kitchen in her PJs online. And she would have had to take hundreds of hours of courses about buying and selling houses, which she didn't do and didn't want to do. So rather than go through all of that, Sally shut down her business, but then she found us. And we helped her file a lawsuit under Pennsylvania's Constitution. And the basic idea of the case was, as applied to this lady and the services that she is performing, it is irrational for the government to require her, and oppressive, to get a full-on real estate broker's license. And we invoked Article 1, Section 1 of the Pennsylvania Constitution, which I'll talk about a little bit later. But it's basically thought of in the state courts as a kind of analog to the 14th Amendment's due process clause. And there are serious problems with treating it as an analog, but that's kind of how it's conceived of. It's sort of the font of the protections that the state offers for economic liberty, to the extent they exist. And so we litigated this up to the state Supreme Court. And one of the basic issues in the case was, what is the test that should apply to the regulation that she's being forced to comply with, right? And if you know anything about federal constitutional law, going all the way back to a case called Caroline Products, the courts have basically divided rights into sort of fundamental, in other words, important rights, and non-fundamental or unimportant rights. And the rights that courts say are important get what's called strict scrutiny, right? The government bears the burden. It's an evidentiary burden. They have to prove the law is narrowly tailored to serving a compelling interest. Other rights, the unimportant ones, according to the courts, get rational basis review. And that test has sort of waxed and waned over time in the courts. But in the federal courts, it drifted throughout the 20th century to a kind of conceivability test, where a law didn't just have to be rationally related to the government's interests, but instead it could just be conceivably related. And so we could talk about that test for hours, but that's the basic divide, right? Strict scrutiny, rational basis review, and in federal courts sometimes it's conceivability review. Okay, so then the question is, what test applies under the Pennsylvania Constitution? And since about the 1950s, but arguably further back than that, the court has applied a different kind of rational basis test, one rooted in kind of more traditional police powers jurisprudence, and the test has two parts. It says that a law has to have a real and substantial relationship to a legitimate end and can't be unduly oppressive or patently unnecessary. And a key feature of the test is that a plaintiff can use evidence to prove irrationality, whereas in federal courts, sometimes courts will treat the evidence as irrelevant. So the court held in 2020 that we had stated a viable claim. We ended up litigating the case and winning after a trial. But the reason I'm talking to you today about this is not to brag about that, but to say that Justice Wecht, on the court, who's currently there still, wrote a very, very fiery dissent of the majority's opinion, sort of his magnum opus on this topic. And he's been beating this drum for years ever since that this test is total nonsense. And the argument he makes is essentially that there's no textual or historical basis in Pennsylvania for departing from federal due process jurisprudence, and that Sally's right turn of living that she invoked was, he says this sort of ironically or with a scathing tone, found in a secret repository of unenumerated rights in the Pennsylvania Constitution. So in his view, it's not a real right. It's not a real state constitutional right in Pennsylvania. And the basic point of my paper is, it is a real state constitutional right. It's rooted in the text and the history of Article 1, Section 1. So what does Article 1, Section 1 say? This language has been basically unchanged since 1776. Anthony and others have written about these as Lockean natural rights guarantees, I think for good reason. But the language, at the risk of reading you a quote that's too long, that all men are born equally free and independent, so born free and independent, have certain natural, inherent, and unalienable rights. Among those are enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. And so my basic take on this language, and the paper goes through some historical evidence, and I'll give you a few highlights, is that the right to life, the right to acquire property, the right to pursue happiness, these are rights that necessarily entail economic activity. They necessarily entail working and productive labor and trading the fruits of your labor with other people in a free society. And that's baked into the text. And so, yes, the text is phrased a bit abstractly, but that is one of the things encompassed within it. So I want to go through just a few pieces of evidence that I cover in the paper. All this is really drawn from what the Pennsylvania Supreme Court has told us it cares about. And so one of those things is contemporaneous dictionaries, right? So what were people saying about the language at the time? Now, I realize there might be scholars in the room who have issues with using dictionaries to kind of resuscitate original meaning. We don't have to do that here necessarily because the court has told us dictionaries matter. So if you look at some of the big dictionaries in the years leading up to 1776, all these terms do have definitions, and we don't have to go through all of them. But suffice it to say, acquiring property, you could read that language as engaging in labor, productive labor needed to gain possession of the property, right? Life is a self-sustaining kind of action. It's animation. It's activity. Pursuing happiness. I mean, these all have sort of common, plain meanings that clearly encompass productive work and economic activity. Number two, there's a clear intellectual context to the adoption of this language. I referred to Lockean natural rights guarantees earlier. I mean, this language comes from a Lockean tradition. I realize that's maybe an oversimplification. There are other philosophers, natural rights philosophers, that would have inspired the people who were drafting these provisions. I don't want to discount that. But the Pennsylvania Supreme Court itself has told us that Locke was a huge inspiration for the founding generation in Pennsylvania. And all this language, you can find iterations of it in Locke himself when he's talking about being in a state of nature, having to sustain your life through productive work, the origins of property, being in labor and productive activity. And so this is not coming out of nowhere. It's coming from an intellectual tradition. And finally, there were people who were talking about property at the time this provision was adopted and in the years following as a product of labor, as a product of work. Right? And so it's not accidental. Again, you get language about acquiring property right there in the plain text of the Pennsylvania Constitution as a product of liberty. One final detail I want to just flag for you as my time runs a bit short is one I think folks might find kind of fun. So Benjamin Franklin, many folks know, was an editor of the Pennsylvania Constitution. And Article 1, Section 14 of the original Constitution has a provision that I think folks have referred to today in different contexts, one of these sort of unenumerated rights provisions, you might call it. I think it's more than that here. He actually enumerates some things. He says a frequent recurrence to fundamental principles, including industry, is the word, including industry, is necessary to preserve the blessings of liberty. The people ought therefore to pay particular attention to these points in the choice of their representatives and have a right to exact due and constant regard to them from their legislatures and magistrates. So you have a right as a citizen to exact regard for industry in the courts, right? That sounds like a judicially enforceable right to earn a living, to engage in productive activity. And if you look back at Franklin's writings or other contemporaneous sources, industry is not the sort of thing we think of it as today, like sort of what's the GDP of the country. It's a personal virtue. It's laboriousness, right? It's acting to sustain yourself in a productive way. And there's all sorts of other stuff that I talk about in the paper that's sort of like that. But the upshot is the right to earn a living in Pennsylvania is not just made up. It's not enumerated. It's not in some secret repository somewhere. It comes from the plain text of the Constitution, read in the context it was adopted, and it has deep historical roots. And so if we are choosing between a conceivable rational basis test, right, where facts don't matter, and this heightened test that Pennsylvania has decided to apply, to say nothing of strict scrutiny, we should choose the heightened test, right? We shouldn't go to the cellar of constitutional law for this important right.
Thank you, Josh. Professor Cottrol, whenever you're ready.
Thank you. It's my privilege to be here with you today to discuss these two thought-provoking papers. Both of them invite us to expand our understandings of American constitutionalism by looking at what I would argue is the still underexplored area of state constitutions and their influence on general constitutional law, and of course the role that history should play in constitutional interpretation and assessment. Professor Burns's paper provides us, in part, with a cautionary note as we approach what will and should be a celebration of the 250th anniversary of the United States. That celebration should recognize the nation's many triumphs, not the least of which is that the ideal of a free society survived the perilous 20th century in no small measure due to the sacrifices of the American nation. But that celebration should also recognize that the very foundation of the nation, in no small part, rested on an immoral compromise with slavery. The founding generation, including Jefferson, recognized the moral evil that slavery represented, as shown by his initial efforts to use the slave trade as part of his indictment of King George in the early draft of the Declaration of Independence. Sadly, as we all know, that early draft was deleted. Jefferson never realized the abolitionist potential represented in that early draft, and despite qualms that he expressed in the Declaration and elsewhere concerning slavery, he remained a slaveholder and a supporter of the United States as a democratic republic for whites only throughout his life. Jefferson's dilemma of recognizing and becoming reconciled with the evil of slavery must be seen as part of a broader schizophrenia that the nation had concerning slavery at the very founding. The nation's liberal revolution for independence, like the liberal revolutions that produced independence from Spain's colonies in the Americas, raised the question, why can some human beings be enslaved in new nations that are fighting liberal and egalitarian revolutions? That question hit hard in the new nation that would become the United States. That sentiment led to the first mass emancipation in the Americas, the abolition of slavery in the northern states, an event that has too often been underappreciated by historians. It should also be noted that the recognition that slavery and the ideals of the revolution were incompatible also led to large-scale private manumissions in the Upper South and legal change in some states that facilitated manumission. Professor Burns focuses on the under-considered question of state constitutions and their efforts to regulate and restrict the African slave trade. Here, Professor Burns gives us a good picture of the mixture of motives that informed this state regulatory effort. These included humanitarian considerations. The horrors of the African slave trade were well known and quite visible to the 18th century generation. Fear that the slave trade would bring about an increased black population, increased possibility of slave revolt. And three, fear that an increased black population, as Professor Burns properly notes, in some cases, an increase in the Irish population as well, would disturb the vision of founders like Jefferson and Virginia jurist St. George Tucker, who sought an ideal of small-scale, homogeneous republicanism where citizenship was limited to a white and, in some cases, Protestant yeomanry, with blacks and, in some cases, others effectively excluded from this Republican ideal. Professor Burns's discussion is particularly valuable because it points us towards the mixture of motives that lay behind the seemingly anti-slavery effort to restrict the slave trade. This discussion, I would argue, points us to the complexities of trying to tease out the motives of historical actors and the need to always be aware of the mixture of motives that in fact informed historical actors and the legal legacy that they have left us. Professor Burns's essay provides us with something of a clue as to how we might assess the historical forces and motives of legal actors in the past. Mr. Windham's concerns are more those of the modern lawyer. How should history guide the modern jurist in deciding present-day cases? This has always been part of the American constitutional jurisprudence, and there has been a renewed emphasis on the use of history in constitutional litigation in the 21st century. Witness the Second Amendment cases and the court's hearings on birthright citizenship just a few weeks ago. Mr. Windham wants to give the right to earn a living a firmer constitutional footing and seeks to use the Pennsylvania Constitution and the jurisprudence of the Pennsylvania Supreme Court as vehicles by which that right might be fortified. I have not had the time to look at the jurisprudence of the Pennsylvania and other courts with respect to the right to earn a living, but I think I can try to summarize Mr. Windham's historical argument, if I might. The right to earn a living should be inferred as being implicit in Pennsylvania's Declaration of Rights, adopted in 1776. That declaration was heavily influenced by the writings of John Locke, with its emphasis on liberty and property rights, and 18th century Pennsylvania's political and legal commentators who praised the virtues of industry. The 18th century atmosphere that produced the Declaration was certainly one in which citizens would have agreed on a fundamental right to work. The difficulty with this argument, and I confess my not knowing the jurisprudence concerning right to work cases adds to the difficulty, is it is not clear what the boundaries of this right may be. With the right to work, we are dealing with the problem of unenumerated rights at a somewhat more challenging level than normal. We are all familiar with our different travails concerning substantive due process. These problems are multiplied in a discussion discussing a right to work in the Pennsylvania Constitution, which even lacks, as Mr. Windham informs us, a due process clause as such. But assuming a right to work, how do you treat it? As Mr. Windham would like, as a fundamental right. How do we treat it that way? Obviously, the courts will not be treated or not be presented with a case which gives them the reductio ad absurdum, legislation essentially saying that nobody has the right to work, all must not work, and instead are required by law to starve to death, and indeed all of society is required to perish. Presumably, that kind of legislation will not appear in court, will not be, presumably, hopefully not contested in court. But presumably various kinds of discrimination based on race, gender, religion, and so forth are already covered by federal and state anti-discrimination law, with any government causing or prompting of such discrimination is presumably covered by the Fifth and 14th Amendments. So where are we going to find justiciable violations of the right to work that are likely to occur, and how to develop ways of measuring, if we might, their constitutionality? Before we go too far in attempting to answer such a question, I must express a fear and raise a call for caution. We may be in danger here of a kind of constitutional bootstrapping. That is, we acknowledge Locke believed in liberty and property rights. the framers of our 18th century constitutions were certainly students of Locke and meant to incorporate his ideas in their constitutions. And we continue down this road, and suddenly we find that all sorts of labor protective legislation that we have developed in the 20th century is unconstitutional. Not because of a specific identifiable provision of state or federal constitutions, but instead because of a problematic process of constitutional bootstrapping, sort of Lochner, the sequel, if you will. So how might we use Mr. Windham's insight that the Pennsylvania and presumably other constitutions, including the federal, might be properly read to incorporate a right to work? One suggestion that comes to mind is that we might borrow from the Supreme Court's jurisprudence in the Second Amendment area. New York State Rifle and Pistol Association versus Bruin states that in the era of firearms regulation, we should look to 18th century firearms regulation as a guide to what the framing era generation regarded as permissible regulation under a constitutional mandate to protect the right to bear arms. Would something similar work with respect to regulation of employment and a constitutional right to work? We would have to approach such with due caution. Historians of labor law, such as Robert Steinfeld, inform us that well into the early 19th century, even putting the question of slavery to one side, free labor was something of a minority arrangement in the Anglo-American workplace. How do we then apply history and the history of labor regulation, or early history of labor regulation, in recognizing a right to work or a right to self-employment or employment? All of these questions notwithstanding, Mr. Windham's The Right to Earn a Living in Pennsylvania is a thought-provoking essay that causes us to ask some fundamental questions about constitutional rights and the role of history in determining such. I learned a lot from both papers.
Thank you, Professor Cottrol. I believe we have some time to allow Robinson and Josh to respond to your commentary before we open it up to questions. Robinson, do you want to start us off?
And I'll simply start with thanks, and that your work has shaped mine for some years, Professor Cottrol. And I think revisions, I'll try to center what you put very nicely, which is that there were plural motives underlying this language in the Declaration and related anti-slavery or non-importation resolutions. I think that, again, that vehement Philippic Jefferson's declaration that George waged cruel war against human nature itself, often that language is what we center, but not so often do we look at the sort of plural motives behind it. Establishing motives behind any legislation is difficult, and it's something I struggle to do, but I appreciate your sort of pointing out how complex those motives were, so thank you.
Yeah, I appreciate the thoughts a bunch. You said Lochner, but you did it in a much nicer way than Justice Weck did, so I thank you for that. I guess the main thing I would say, I guess as a responsive thought, would be that the article is intended to be relatively modest. It's not intended to call for a sea change or anything like that in the law. It's basically intended to say that when a sitting justice tells you that this is a totally made-up right, that's not correct. There's a lot of evidence that it's a real right, that it's rooted right there in the text, right in the historical context when it was adopted, and that if you take that into consideration, it leads you down different jurisprudential roads under existing doctrine, right? So it might be, for example, that like other fundamental rights under federal law, strict scrutiny would apply to the right to earn a living. My article doesn't necessarily call for that, but that's one way you could approach it and just say the government sometimes does have compelling interests in restricting this liberty, just like it might have a compelling interest in restricting your freedom of speech, right? And then the government bears a burden that has to overcome to restrict that right, and that's a familiar jurisprudential framework that applies to other fundamental rights. My article doesn't even go that far. It just says that for choosing between two different versions of rational bases tests that are sort of articulated over decades of jurisprudence, the one that cares a bit more about reality is the one that sort of better respects this important right. So thank you.
Thank you, Josh. Professor Cottrol, would you like to respond to either of their feedback? No? Well, then I think we have some time for questions. While folks are preparing to line up at the microphones on either aisle, I'll kick off with a question for both of you, dealing with what I saw as kind of a little bit of a tension between the two papers. You know, Josh, you argue that Pennsylvania's Declaration of Rights encompasses this right to economic liberty. Robinson, one of the themes that you trace behind these non-importation clauses is mercantilism, the desire to protect some economic interests over others. Can the two views in your respective papers be reconciled? Am I overblowing this tension? Is it there? Help me kind of sort through how that tension should be resolved if it can.
I guess I'll say something limited in response, and maybe Robinson can give us a better response. But I was fascinated just to learn or remind myself in researching for this paper, the sort of, and Anthony, I give you credit for reminding me of this, the history of Article 1, Section 1, and sort of how it came to be. George Mason had this original draft of Virginia's, list of rights, and one of those is the sort of precursor to Article 1, Section 1. It's very similarly phrased. His original draft is the one that made it through publication in newspapers to Pennsylvania. They later revised that draft in Virginia to appease slaveholders. And so Virginia's constitutional language actually ends up appeasing slaveholders, whereas the draft that was adopted in Pennsylvania doesn't have that appeasing language. And so I think Pennsylvania, I know less about the sort of broader history, but I think Pennsylvania is a state that, generally speaking, was less amenable to slaveholders than Virginia.
That certainly was right, and many Pennsylvanians at the time would have agreed. So I'll point to one sort of, point of commonality overlap, which is the difficulty of establishing meaning in old documents, especially when those documents, as Dr. Cole regularly shows, have been edited continuously. So if you go to the University of Pennsylvania's archives, you'll find Benjamin Franklin's original copy of the Frame of Government of Pennsylvania, which they will let you see, or at least they did let me see it when I was 23 years old, which was a bit surprising. And in that is a redacted clause, which I'll read for you. It was actually one of the center clauses, and it was cut for brevity, not because it was contentious. It was actually understood to be the animating spirit of the Pennsylvania Constitution, but it was cut simply because it was a bit too long to actually encompass a meaningful right. Here's the actual phrase, quote, "An enormous proportion of property vested in a few individuals is dangerous to the rights and destructive to the common happiness of mankind, and therefore every state hath a right by its laws to discourage the possession of such property." In the original Pennsylvania Constitution is also a right to be protected from too much wealth. That is to say, there's a strong limitation on how much a person can acquire. This is a distinctly Lockean right. As anyone who's read C.B. Macpherson, the philosopher, will know, Locke says in Chapter 5 of Property of the Second Treatise, you can't acquire too much property. It's not actually clear the framers of the Pennsylvania Constitution were themselves reading Locke, right? So if you look at Rosalind Branning or Theodore Theodore or Paul Selsom or Gordon Wood, they're actually reading these communitarian thinkers, the Old English Whigs, who Locke was in dialogue with, but there's a strong limit on over-acquisition of property, and this language appealed to the framers of the Pennsylvania Constitution, who were Presbyterians, Scots-Irish poor farmers who actually took over the convention. They formed a majority of seats in the convention and wanted to make sure that there were provisions in the Constitution to cut down on over-acquisition of property. It's oddly not exactly a right to work, but a sort of communitarian right that many democratic socialists today might find appealing. It gets redacted from the Constitution, though, so does that matter at all? And more importantly, would a judge care? That I don't know, because I'm a political scientist.
I think now we have a couple of questions. Start us off.
This is for Mr. Windham. Much of your talk focused on a more individual right to earn a living, for use of a umbrella term there. But I was wondering if you had any remark on kind of a corollary that you see at common law in discussions on monopolies, where they're focused on government-backed monopolies, and a lot of the common law jurists would describe those as inherently contrary to the public interest for purposes of being against consumer benefit, but also for the incidental burden on the right to participate in a lawful occupation. And I was wondering if you had any remark on that aspect and that corollary of there's also this limitation on government that you can see in common law and setting up monopolies, something maybe analogous to a state licensing board that might be something more similar to those old patent corporations or chartered corporations that had a monopoly.
Yeah, so I think it's, I mean, I'm persuaded by those who have argued that the early state constitutional anti-monopoly clauses are at least evidence of the fact that there was a generation of folks who were drafting constitutions at the time who would have understood there to have been a kind of right to earn a living or economic freedom baked into the constitutional fabric. So that seems right to me, although of course I litigate these cases, so take it with that, whatever grain of salt you want to give it. The other thing I'll say though is that when you're thinking through how should this work in court today, you know, earlier I was talking about different versions of the rational basis test and strict scrutiny and other types of standards. We heard about the Bruin test earlier. I mean, these are all kind of judicially, I don't like judicially invented as a way of casting aspersions, but they're judicial attempts to actionalize, right, rights that are found in the Constitution. And so the question is sort of like, how do we make this real? How do we make it justiciable, to use a phrase that was used earlier? I guess what I would say about the monopolies clauses is that, you know, one thing that's nice about them is that they're phrased very categorically. They're just phrased as the government can't create monopolies, and then it just ends, right? It says they're contrary to the genius of a free state and shall not be allowed. That's the actual language. But, you know, the thing that's nice about them is that they don't give rise to any obvious inference that we should be applying some kind of means-end scrutiny or rational basis test or any other kind of test. It just says no monopolies. And so it sounds to me like right there in the Constitution is a declaration that the government can't do something specific. And then the question is just, what is the something specific, right? So that's a fun inquiry.
Dana?
So there have been a couple comments about portions of the Declaration or of the state constitution that were omitted and how meaningful they are. And it's interesting because usually when you're in court, if something was omitted from a statute, then that means they meant to omit it. That's the canon of statutory construction. But what I'm hearing is that maybe that's actually not true. And that, for example, with the anti-slavery declaration that was omitted, or provision that was omitted from the Declaration, that it was still meant to be there, but more implicit. You just talked about another part of the Pennsylvania Constitution that was omitted, but omitted for brevity. So I'm wondering how we know what portions of these documents, when they're omitted, if they actually are still kind of there or should be used to interpret the meaning of the language that remained.
Good question. So I would say that statutes and constitutions are products of accident and force rather than reflection. We might look at the Pennsylvania Constitution, for example, which was a wartime document. It was written very quickly by 108 people who met in initially in Carpenter's Hall next to the State House and then in the State House. It's not clear that they actually had a sense of intent behind the document, but rather were brokering a series of compromises between a faction of counties to the west of the state that had periodically threatened secession and had attempted to burn down what then were royal buildings and eventually what became state buildings. And on the other hand, more established Eastern, more Philadelphian moderates who were trying to rein them in. It's not clear to me that they thought about judicial interpretation, in part because judicial interpretation was only just emerging in North Carolina at the time, and they likely understood that their legislature would have the power of interpretation. So what ought we do then to establish intent when we have these state constitutions as products of accident and force? I might point out that, for example, Colorado entered the Union in 1876 when a meeting of framers, initially they'd met at Aurora Tavern, and then a handful of territorial legislators kind of slapped together a constitution just so that the Republican Party could get enough electoral votes to make sure that their party carried the presidency. It's not clear that many of these original constitutions are sort of, that the framers of them intended the kind of interpretation to which we subject them. And yet we must subject them to this kind of interpretation because we've sort of walked backwards into this set up for establishing meaning. So to your original question, what do we do then with a redacted clause? I think it's merely evidence that these are products of factional debate, and that it shows that there were different people in the room who had different and often irreconcilable views as to what a document ought to mean. I think plural interpretation is a much more humble way of approaching a document rather than saying I have correctly established what this Constitution meant, especially given the framers of the Constitution themselves often rarely knew what the documents meant.
I guess I don't have a ton of thought on when something was originally in a draft and never made it into the constitutional flow of the chain of reasoning to begin with, although I do have a thought on when something is in an original constitution and then doesn't show up in a later constitution. So I mentioned this sort of industry as a virtue and as a fundamental principle that was added by Franklin to the original Pennsylvania Constitution. Well, it doesn't show up in later versions of that Constitution. So you might ask yourself, did they all of a sudden stop caring about industry? But I don't think the answer to that is yes. I think, when we're thinking about language in Article 1, Section 1 that was, preserved over the course of 250 plus years, at the time it was first used, it was paired with the fundamental principle of industry. And so I think that's a way of thinking about that original text that has been carried forward, even if this sort of contextual clause has dropped out over time through editing and recodification and that kind of thing.
Yeah, my question's for Mr. Windham. With regards to your test for the right to learn or earn a living, I'm wondering, the situation you're applying it for in the Pennsylvania case was a case where the underlying conduct is permitted so long as you have a license. Can the state get around the right to earn a living in that case, say, for example, by just outright prohibiting Airbnbs? Or if they do outright prohibit conduct such as Airbnbs, say they put a ban on banking or other economic activities, is there still a right to earn a living with that activity that is preserved and actionable in court?
Yeah, so we might be just talking about a different iteration of the right to earn a living, but there's, and by the way, I want to clarify, it's not my test, it's a test the court has applied that I support. But with that said, there's a sort of 75-year history of a bunch of cases where the court has applied this test to things like outright prohibitions on the sale of certain products or the provision of certain services. And even in those cases where we're talking about an outright prohibition, the court says, look, people have a right to provide a healthful, valuable, non-harmful service or product in a free society. Right? So as long as you satisfy the test, right, as long as you can prove that this is not bear a real and substantial relationship, or it is unduly oppressive, or whatever the standard the court wants to apply is, as long as you can kind of overcome that, you can prove that, banning me from selling filled milk is actually unconstitutional, right?
Anthony?
So Robinson, I learned a lot from your paper about, but when you step back and think about it, especially in light of current tariff policy, it makes a lot of sense that there were people who were pro-slavery, who were very into themselves owning slaves, who were against slave importation for various reasons. And it sounds like at the time it was most mercantilist, but also this anti-slave revolt view of how imported slaves might behave differently than their own homegrown slaves. And so in thinking about that, and then thinking about later abolitionism and abolitionism in the old British Empire, which of course finally happens in 1820s, 1830s, is this different view of, or the different, I guess, environment of where we banned the importation outright in 1808, famously, under what the Constitution allowed, and then people, slave owners depend on their local enslaved population perpetuating itself, versus the situation in places like Bermuda, Jamaica, where things were even, from my understanding, even worse for those people. And so you needed to keep importing slaves. How did that change? This goes, I guess, beyond the conference, so I apologize. But how did that change abolitionism, and did it make it easier to a great extent for the high-minded people in London to do that and kind of put the screws on the property owners in Bermuda versus what we all know happened here?
Yeah, so if I can say the question back, was abolition in the British colonies easier because, and I need the last part there.
Right. Easier because both the mercantilist environment was different, and also because they depended on importation in a way that Americans did not.
Got it. There it is. That is a good question. The two movements, American abolition in the sort of what Professor Cottrol points out to, is sort of this neglected early wave between the 1760s and then early 1800s. It emerges out of a similar sentiment from British abolitionism, which is this sort of moral sense idea that human beings are going to be naturally, if they're simply shown the horrors of slavery, they're going to be naturally opposed to it. And that sort of worked a little bit in the North, where the enslaved population was more marginal economically and in terms of numbers. There were northern abolitionists who went south in the early 1800s to try to explain to slaveholders, white abolitionists, that slavery was inhumane, and many of these abolitionists got hung. The British had a slightly different approach, again, born out of sort of moral suasionism, but there's this famous 1772 case, the Somerset case, which abolishes slavery on the British Isles. It says famously the heir of England is too pure for any slave to breathe. That's derived from an earlier 1706 case. But it's through that sort of that attempt at moral suasionist abolition that the British are pushing. Ultimately, that culminates in abolition in the British West Indies in the 1830s. It is the case that sort of economically the British West Indian colonies were economically viable. They produced a lot, and so it represented to some degree, I guess, a greater sacrifice for the British economically to abolish slavery in their colonies then, which were producing, especially sugar cane, and sort of great economic production. So I don't know if that directly answers it, if only to say that there's sort of a common intellectual origin for those two moments of abolition, and then they sort of move a bit differently.
If I could just interject something here also. I think one of the things we've got to do in terms of discussing slavery is not to confine our considerations simply to the Anglosphere. The really important story, or the major story of slavery in the Americas, is actually in what would become Latin America. And you've got very different dynamics occurring, including, at least in the Spanish-speaking republics, the abolition of slavery as part of their liberal revolutions for independence. So let me just say that this is a discussion that we need to expand and make it much more of a hemispheric discussion, and not simply a dialogue between the United Kingdom, the United States, and the Caribbean. It's more complex than that.
We have time for one more question. Just one more question. There we go.
So my experience of advocacy in modern times is that sometimes when one is taking a strong moral position that is unpopular, one makes arguments and you throw in alongside your basic moral position a lot of utilitarian arguments about taxes in a sort of desperate attempt to collect any allies you might be able to collect for any reason. And I'm wondering if some of that can be identified in the discussions of slavery in the late 18th century, or if it's all just this completely grim confusion of motives without a strong core of moral suasion somewhere in there.
A good question. So to what extent was the anti-slavery rhetoric earnest or meaningful? I think it's hard to establish motives or to understand what legislators meant, but in Jefferson's own writings on the Declaration, he seemed frustrated that his language was removed, and Franklin later wrote that Jefferson seemed perturbed as well, and that might have been pride at seeing what he saw, the culminating clause taken out of the Declaration. But there, parallel to this, in the non-importation language, the language to establish tax autonomy was a real sort of frank frustration among Virginia legislators and colonial legislators that their attempts to regulate the international trade were being vetoed. There was, I think, it may not be the case that couching this anti-slavery work in the language of taxation was sort of a convenient way to overcome some of the unpopularity of abolitionism, particularly in the South. I think that they were earnestly frustrated about taxes. Patrick Henry gives us the Stamp Act resolutions, and he also pushes to establish Virginian authority over the international slave trade and the power to tax it. But that I think is also sort of, to your point, it might be prudent sometimes to put morally right but unpopular language in the more neutral language of taxation and tariffs. And so there may also be some prudence underlying that, in that there were some slaveholders who were opposed to anti-slavery language, but maybe some of them would have accepted the tax autonomy language.
If I could just add a kind of footnote to this. I see my job on this panel is raising complicating questions, if I can. And so let me throw in, included obviously with the question of slavery, is the question of racial exclusion and racial inclusion. And let me end with a kind of fact that we might want to say, what do we do with this? How do we approach this? At the time of the adoption of the Constitution, a majority of states allowed free black men to vote. In fact, the only 3 states that didn't were Virginia, South Carolina, and Georgia. All the rest, including states that in the 19th century would be slave states, allowed propertied free black men to vote. What do we do with this evidence of racial inclusion in the land of slavery? And how do we deal with this? How do we fit this into our discussions of the attitudes towards slavery and the related but distinguishable attitudes towards race? So just to throw that out.
I think it's a perfect complicating note to end on right before we all have an opportunity to go and talk amongst ourselves at lunch, I believe. So lunch is next. Let's give a warm round of applause to our panelists. And now we can break for lunch across the hall, I'm told.